In this lecture, we would like to discuss about public liability law in India. So, the Public Liability Insurance Act of 1991 regulates mandatory liability insurance. Under the law, companies must commit to installing and handling hazardous materials that have been reported under the Environmental Protection Act of 1986. It is basically part of tort law which focuses on misconduct of civil law. The applicant, the injured party, usually sues the accused owner or convict according to general law due to negligence and or damage. Claims are generally successful if it can be proven that the owner occupant is responsible for the injury and therefore violating his maintenance obligations. Once a due diligence violation has been identified, a lawsuit in a court may succeed. The court will provide financial compensation based on the applicant's injury and loss. As the rate of such dangerous industries grow, it is a threat not only to the employees or the worker, but also to the people nearby. And what are the basics we found about the Public Liability Insurance Act of 1991, which deals with hazardous substances such each owner must conclude one or more contracts which include the obligation to provide direct compensation. It should be provided to all those who have suffered damages that should be given to the property of the deceased legal heirs in the event of their death. So, in the 1991 Public Liability Insurance Act was framed to provide direct assistance to people affected by accidents related to handling hazardous materials and other related matters. Coverage insurance is claimed when someone is injured at the place of business. Places like shopping centers, nightclubs, and theaters need this type of insurance to protect themselves. The Public Liability Insurance Act 1991 applies to all owners associated with the production of or handling of any hazardous chemicals to provide immediate relief to victims and persons other than workmen affected by accidents occurring while handling hazardous substances through the insurance amount paid by the owner of the hazardous substance. Coverage insurance covers claims by community members who have suffered injury or property damage in connection with the business. Coverage insurance covers a person or company in the event of an accident at their company. The major reason for enactment of the 1991 Public Liability Insurance Act was due to the Bhopal gas tragedy. So, we would like to discuss the leading case, Union Carbide Corporation versus Union of India, etc. on May 1989. It is also known as the Bhopal disaster, in which thousands of people lost their lives. This is considered the worst industrial disaster in the world. That happened on a cold winter night in the early hours of December 3, 1984, and around midnight. A chemical reaction began at the Union Carbide India Limited plant at Bhopal, which resulted in the release of a deadly gas, and that is methyl isocyanate from one of the tanks of the Union Carbide India Limited. As a result, the gas cloud gradually tumbled, involving the city within its deadly falls. Both the city and the lake had become a gas chamber. Nearly 3,000 people died in the tragedy and thousands more were physically injured and affected in various forms. Wildlife was killed, injured, and contaminated. The business was totally cut off. People's lives were affected. The environment was polluted, disturbed. Ecology and wildlife. An estimate 40 tons of methyl isocyanate gas leaked from the Union Carbide factory at Bhopal. Lessons learned from the Bhopal gas tragedy were quickly forgotten, but the Public Liability Insurance Act 1991 came into force after the tragedy and aims to provide immediate assistance to victims of accidents involving hazardous industries. However, activists argue that legal provisions are not enforced by collectors appointed as law enforcement agencies. According to Section 4 of the law, owners of companies that use hazardous substances take out insurance policies to cover liabilities from accidents that cause death, injury, or in addition, Section 7A, which regulate the establishment of a central government environmental promotion fund to be used in accordance with the law to pay assistance to accident victims in dangerous companies. The law also regulates business owners to take insurance policies that cover obligations not less than the paid off capital of the business and not more than Rs 50 crore. In Bhopal leak gas case, methyl isocyanate leaked from the plant of Union Carbide India Limited, which caused the death of 3,000 persons and serious injuries to a large number of people. So the government of India responded with a number of concrete legislative measures, such as Environmental Protection Act 1986. This extends the central government power to enter, inspect, and close down facilities that are formerly under the inadequate supervision. The Factories Act 1987 and the Hazardous Waste Act 1989 imposed various responsibilities on industries. The innovative Public Liability Insurance Act of 1991 required factory owners to ensure against potential personal injury and property damage in surrounding communities. And in that case, also, you would like to discuss another important leading case, the Vizag gas leak, and that is relating to the LG polymers. So, the gas leak at LG Polymers chemical plant in R. Venkatapuram, village, Visakhapatnam in Andhra Pradesh. So the very disaster affected people in the Gopal Patnam region in Visakhapatnam, Andhra Pradesh, on the night of May 6, 2020, respiratory problems occurred and nearly 13 people were reported to have died in a very short period of time and thousands were hospitalized with serious complications. The leak was discovered from LG Polymers India Limited. This produced polystyrene, a type of plastic used in consumer goods such as toys and household appliances. The gas that comes out is called stearin. This gas is stored at cold temperatures. This resulted in a chemical reaction and it being released in the tank, causing gas to come out. Inhaling air contaminated by this deadly gas caused respiratory problems, central nervous system depression, and several other deadly diseases. So the Prime Minister took cognizance of the accident and the National Chemical Disaster Management Force for the Chemicals, Biology and Radiology and Nuclear special team was moved by the scene of the accident. The Andhra Pradesh High Court, the National Human Rights Commission and the Apex Court. The Supreme Court took suo motu cognizance about the case and sent communication to the central and state governments to investigate the incident. According to the Public Liability Insurance Act, company owners must take out an insurance policy with hazardous substance within 1 year after starting work. LG Polymers has two policies. One that is the Public Liability Act policy, which is mandatory according to the Act. Any one accident of RS5 crore and also has an industrial policy limited to 5 crore. Both are from New India Assurance. So, RS5 crores means that the company will be liable to pay up to RS5 crores in total for all victims for accident. Also, the central government can establish an environmental support fund to provide legal assistance to accident victims in dangerous companies. So the National Green Tribunal issued the orders under Section 14 and 15 of the National Green Tribunal Act of 2010. The National Green Tribunals made a provisional determination of RS50 core on LG Polymers India and pursued a response from the center in the gas leak incident. Andhra Pradesh saying there seems to be a fault in fulfilling the old rules and other statutory provisions. And now we'll discuss the very objectives of the Public Liability Insurance Act of 1991. This law provides liability insurance for the purpose of immediate assistance to those affected by the accident while handling hazardous substances and related matters that can cause an error. Legal consequences are produced by law because it is not an adequate announcement of the provisions of Section 3 of the Act. The growth of dangerous industries affect everyone either directly or indirectly. Such accidents result in death and injury to people and other living things and damage personal and public property. Very often, most of those affected come from economically weaker regions and suffer great hardship due to late release and compensation, while employees of hazardous facilities are protected. The community is not guaranteed assistance except through lengthy legal procedures. Industrial facilities are rarely willing to easily compensate victims of accident, and the only way now available to victims is to bring prolonged litigation to court. Some units may not have been as regarding such. We found that in case of any such accidents caused due to these hazards, so the only way now available to victims is to bring prolonged litigations. So the major provisions that we found in regards to Public Liability Insurance Act, as it is defined under the Act, an accident is a sudden or unexpected incident which is related to a hazardous substance that causes continuous or temporary exposure or injury to a person but does not result in an accident that is solely caused by war or war radioactivities. Also, to deal with hazardous substances is to manage the production, handling, packaging, storage, transportation of vehicles, use, collecting, destructing, conversion, making of arts for sale, removal from each hazardous substance. Insurance is as provided under subsection 3 of section 1 of the Public Liability Insurance Act. The owner is the one who controls and handles hazardous substances at the time of accident. So also the partners in case of a company and any member in case of an association, prescribed as the rules made in this act. Relief fund is established under section 7A. The vehicle is any mode used for transport that does not include railways. The obligations of the owners to take out an insurance policy before handling hazardous substance. The owner should have insurance policies regulating an insurance contract in which it is insured, based on the exemption duties as provided under section 3, subsection 1, which where each owner, before entering into an insurance contract, works with hazardous substance, as in each owner will receive an insurance policy which will be extended from time to time before the expiration date, so that the insurance policy continues to apply throughout the period in which the processing continues. From the trade or employer business or railroad employees as defined in section 3 of the Indian Railroad Act 1890, not having permanently employed in the administrative or subdivision territory of the railroad and were not employed in any of the characteristics of the men, navigators or other crew members of the ship listed in Annex 2, or a master or other crew member of the aircraft, someone who has been appointed as a mechanical sweeper, assistant, or in other connection with motorized vehicles, people who work for companies abroad and who work outside India have been stopped, and aircraft or automotive companies can be registered in India, or the injury includes permanent, partial, permanent, partial, and permanent disability or illness related to an accident, any insurance policy taken out or resorted by the owner shall be for the price less than that of the paid up capital of the undertaking that handles any hazardous substance that the owner owns or controls should be more than the price, although should be less than 50 crore rupees or as it prescribes. And as regarding the very reliefs provided under this Act, the very compensation for liability in certain cases without error. As in Section 3, if the death or injury of the other person other than a worker or property damage due to an accident has occurred, the owner is obliged to provide the assistance listed on the list for the death, injury, or damage. In a claim of compensation under Section 1, the plaintiff does not need to declare and prove that the death, injury, or damage on which the claim was based on an action, neglecting or not showing one's performance. So, the very establishment of environmental relief fund, the central government can establish a fund known as the Environmental Assistance Fund through notification. Relief funds are used for payments in accordance with the provisions of this law and regulation under Section 3. Relief in case of assignment by collectors in accordance with Section 7 of the Act. So also we found that in all these cases of Public Liability Insurance Act, as we are discussing the very responsibility and also regarding the very relief that provided. So, in that connection, the claim for compensation and establishment of relief fund, the central government can through notification establish a system that determines the location where the support fund and the money from support is placed is removed funds and for all other matters. And as regarding the provisions as to claim other rights for compensation for death, etc., the right to claim compensation under Section 3, subsection 1 for death or injury to person or damage to property has, in addition to other rights for compensation in connection with other laws or which are currently in force, there is no prejudice as in provision. The owner who is required to apply for help is also required to pay compensation for someone's death or injury or damage to the property. This amount of compensation is reduced by the number of concessions under the law, and very application for claim of relief as provided under Section 6 of Section 1 by the person who has sustained the injury, by the owner of the property to which the damage has been caused, where death has resulted from the accident by all or any of the legal representatives of the deceased, or by any agent duly authorized by such person or owner of such property, or all or any of the legal representatives of the deceased as the case may be, provided that where all the legal representatives of the deceased have not joined in any such application for relief, the application shall be made on behalf or for the benefit of all the legal representatives of the deceased, and the legal representatives who have not so joined shall be impeded as respondents to the application. Every application under subsection 1 shall be made to the collector and shall be in such form contain such particulars and shall be accompanied by such documents as may be prescribed. And as regarding the very award of relief after receiving an application, in accordance with section 1, the collector having notified the owner's request, given the parties an opportunity to be had, will examine the request or one of the claims and can give a gift to label of relief which he thinks is fair, and so the person or person to whom this compensation will be paid. If giving relief according to this section, the insurer which is required to pay the amount of the assignment to the extent specified in section 4, subsection 2b, within 30 days from the date of notification of the assignment, the amount of the deposit in the way of the collector can control. The collector must arrange a grant for this grant and in accordance with the system set out under section 7a to pay the person referred to in paragraph 1 or the person specified in paragraph 1. The owner must deposit an amount that can be instructed by the collector, and also in regard to that, if the insurance company or the owner who receives remuneration in accordance with section 1 does not deposit the amount of his premium within the period specified in paragraph 3, this amount will be replaced by the owner, or if any, by the guarantor, or areas as areas of land, income, or public demand. Claims of damages related to death, injury, or injury to property or damage to property must be addressed as soon as possible and must be released from this claim within 3 months of the receipt of the application for release in accordance with the provisions of section 6, subsection 1. So, these are the very provisions that we have discussed. And as such, regarding the very penalties as provided, anyone who violates any of the provisions of section 4, subsection 1, and section 2a, section 2c, or violates instruction issued in accordance with section 12, will be punished with deprivation of liberty for a period of time which may not be less than 1 year and 6 months, but until it may take 6 years, or a fine that may not be less than 1 rupee or both. So, anyone who has been convicted of an offence under section 1 after the second offence has been convicted of a second offence or another offence will be sentenced to a prison sentence of at least 2 years, which in any case can last up to 7 years, with a fine of not less than a lakh of rupees. So, also, we have discussed all those provisions relating to Public Liability Insurance Act of 1991. So, the very Conclusion on Public Liability Insurance Act shows that it has been enacted after Section 13 of the Rio de Janeiro Declaration of Brazil on the Environment, which was held in 1992. A need to enact this law was felt after the Bhopal gas tragedy. The social responsibility law regulates the authority to request information, entry, inspection, search, and seizure. Owners of hazardous facilities try to provide information that is authorized by the central government. That inspectors naturally need to establish requirements to make requirements, rules, or instructions in accordance with law. Section 12 of the Liability Insurance Act 1991 endorses the central government to give written instructions to any owner, employee, or agent. Instructions also include restrictions and regulations on handling hazardous substances. It can also control the power supply, or it can shut down the very company or factory which causing environmental pollution and which would fall under hazardous and dangerous. So, in this particular lecture, we have discussed the Public Liability Insurance Act of 1991, which enacted on the consequence of the Bhopal gas disaster and the very release of the poisonous gas of methyl isocyanate from the Union Carbide factory in Bhopal. And also we have discussed another important leading case that is relating to Andhra Pradesh. So in this particular lecture, in brief, we have discussed the Public Liability Insurance Act of 1991.